we were here before. Last year, we had almost the exact same crew here, and we were discussing the AI executive order. But now that we have an updated EU AI Act, we need to make sure that you all understand what's going on in the EU. Um, I know it's a big document. It can be really overwhelming. There's a lot of legal jargon in there. So that's why you have Theodora Skeadas here, you have Arushi, and you have David, because they're going to tell you what this all means. So a little bit about the Integrity Institute before we start. The Integrity Institute is like my second home. It's a member-powered think tank in a community, and I can testify to that. And we're dedicated to advancing the theory and practice of protecting the social internet. Membership is currently offered at no cost to anyone, and the benefits include curated gatherings like this one, access to working groups, one-on-one staff support, and member meetups around conferences. If you have more than 6 months of experience on a social platform, like the big ones and the small ones, you might qualify. So make sure that you go to the Integrity Institute website and see if there is a space there for you. And I'm sure there is. So, with that being said, I want to go ahead and get started. I want to make sure that we have enough time to discuss this huge document. And I want my panelists to introduce themselves. And I always start with Theo. I don't know why, but I always pick on her first. So, Theo, why don't you go ahead?
Sounds great. Thanks, Soribel. Hey, everyone. It's really nice to see you and meet you. I'm Theo Skeadas. I'm based in Cambridge, Massachusetts. I run my own technology policy consultancy called Tech Policy Consulting, which works on a number of issues, including artificial intelligence and information integrity and online safety. And I also run a nonprofit called Cambridge Local First, which supports locally and independently owned businesses. And before this, I worked at Twitter, where I managed the day-to-day operations of our Global Trust and Safety Council. I managed a Trusted Flaggers program for human rights defenders globally, and I also managed a research hub for the public policy team. And I supported our global civic integrity, transparency, and crisis response work. And before that, I worked for the US federal government in geopolitical consulting, and I worked in humanitarian assistance before that.
Oh my God. And I'm pretty sure that you're not giving us the whole story. I'm pretty sure you do much more than that. But okay, let's move on to Arushi now.
Thanks, Soribel. Hi, everyone. I recognize some names, but nice to meet those of you who I haven't met before. I'm Arushi Saxena, based in Los Angeles, California right now, and I currently lead trust and safety at a Series A AI privacy and AI security startup, which is called DynamoFL. So the lens I bring today will be from the technologist point of view, but also someone that works on the policy side of technology at a company. Prior to DynamoFL, I was at Twitter. I overlap with Theo, where I was on the information integrity and civic integrity side, working on go-to-market strategy and collecting user insights there. And so that was a fun ride. Before Twitter, I was at Consumer Reports Innovation Lab, where I worked on privacy and also addressed AI policy and data ethics issue when I was at grad school. And so that's over the past few years what I've been up to in this space. I'll kick it off to David.
Yep.
Hi, I'm David Harris. Really happy to be here. I teach at UC Berkeley. I have a couple of classes this year. One is called AI Ethics for Leaders. All my teaching is in the business school. Another is called Scenario Planning and Futures Thinking, where I teach about long-term strategy. And AI has been a part of my courses for a long time. I've been teaching for 9 years. I also advise and hold research roles in a number of different nonprofit organizations, the International Computer Science Institute, the Brennan Center for Justice at NYU, the California Initiative for Technology and Democracy, where I'm actually working on helping legislators in the state of California write legislation about AI right now that's probably going to be introduced in the next weeks or months. This is a really exciting topic for me. My tech industry experience was at Facebook and Meta. I was a researcher and research manager on the civic integrity team, same as one of the two founders of Integrity Institute, Sahar, and also worked on misinformation, social impact, and responsible AI. So I think I first started following the EU AI Act about 2 years ago when I was on the responsible AI team at Meta and started getting briefings from my policy colleagues. And it's so exciting to be here on the other side and having it be a real thing.
Yeah, thanks everyone. And I also want to introduce myself. My name is, I've said it before, my name is Soribel. You know who I am. But who am I? I work in the Senate. I work for Senator Cassidy. I am an AI fellow. I was selected to be here advising the senator on AI policy, and that means anything and everything tech, including AI. Before this, I was at Meta and Microsoft. And before that, I was at the State Department where I was a US diplomat. Um, so before we go into the questioning, I want to emphasize that none of this is legal advice. All the answers that you're going to hear from us are to the best of our knowledge. You should not take it as legal counsel. You should do your own research. We're just, doing this to help everyone in the community. But we're not on the hook if you go and use this in a court. Okay. Okay, I guess we can start. So I'm going to start by asking, the positive things, the cute things, the beautiful things. What are your favorite parts of the EU AI Act and why? And I'm going to start with Theo.
Soribel. And I think it's also worth noting that the three of us, so me, David, and Arushi, over the last year were visiting fellows with the Integrity Institute. And I'll drop our research in the chat. We put together a big legislative tracker on legislation on all tech policy issues, including AI. And it might be interesting for folks to check that out. So for me, I think this is a really defining moment and there's a lot to be very excited about. In particular, I think it's very helpful that the EU AI Act follows a risk-based approach where risks are identified and addressed and in the sense that the higher the risk, the stricter the rules. I think it's helpful that there is a delineation of prohibited practices as well, which include cognitive behavioral manipulation, the untargeted scraping of facial images, scraping of facial images from the internet or CCTV footage, emotion recognition in the workplace and educational institutions, social scoring, biometric categorization to infer sensitive data, such as sexual orientation or religious beliefs, and some cases of predictive policing for individuals. So the idea that there are specifically delineated prohibited use cases, I think is a very helpful framing for the EU AI Act.
Thank you, Theo. And before we move on to Arushi, I just want to remind everyone that this is being recorded. And if you don't want your face to be on YouTube, make sure your camera is off. So just know that. But now I'm going to move on to Arushi.
Great, yeah, and I'll also say these are my opinions, not my company's. So I will put that disclaimer before I share what some of my favorite parts are. There's 3 or 4 things that come to mind. Building off of Theo's point on risk, you all are probably familiar that risk is like a big way, a big framing that underlies the EU AI Act. Specifically for general purpose AI models, like the large LLM models that we think of, GPT and whatnot, those that pose systemic risk, which is the highest degree of risk that a GPAI model can pose in the EU AI Act, there's some very high safety bars and requirements that have to be met. For example, these kinds of models will have to go through adversarial testing. They'll have to ensure certain kinds of cybersecurity measures are in place. Now, that's going to create more process for these providers, but at the same time, what I like is that it's borrowing from the existing infosecurity world that applies to regular SaaS. So when you look at vendors and organizations that are buying major cloud or software solutions, they are also required to go through these kinds of requirements and documentation. And now we're applying that to AI. So I think it's going to create challenges. It's also really good for user safety. A few other things. So copyright. There's also going to be a requirement for copyright policies that high risk AI providers will have to have clearly delineated. And some of you might be following this, others may not be, but there's a lot of debate, legal debate around what's fair use. When can you use copyright material to train your models? When can you not? And having stronger policies around it, I think companies will be forced to take a stance, and that's going to be good for legal protection and legal progress in general. So I really like that companies will be forced to think about copyright and state their policies. Lastly, and then I'll give David a chance to share as well, environmental impact. So we know that it takes a lot of compute power and GPUs to train large language models and AI systems in general. So even though the AUA Act doesn't go into it in extreme detail, it does talk about it at a high level, where it requires model providers to state kind of their compute requirements, track their footprint, and I think it's a step in the right direction. So those are kind of three things that come to mind.
I think so too, and that's, environmental. No one's talking about this, so I'm glad that that's in there. David, what about you?
Well, that was pretty. Oh yeah, thank you. That was pretty thorough from Theo and Arushi. So I'll just +1 all of those items. I think one thing that I really appreciate and we maybe shouldn't take for granted is that the act really survived a series of last-minute attacks from lobbyists who were trying to exclude what they call general purpose AI, or what some people call foundation models. Some people might say frontier models, or that's what large language models, the big ones, are. And so there was a big effort to have the act just omit and exempt and not touch on those general purpose AI systems. And I think it took a lot of wherewithal for the European Parliament and the Council of the European Union to say no to those lobbyists. Now, they did put in a limited exemption for what are called open source AI systems. Now, keep in mind that term is often used in ways that are not accurate. And actually, there's a process right now to create a definition of it. There's not a clearly agreed upon one. But the good news is that the quote unquote open source AI systems that are above a certain power threshold, and in this case, it's 10 to the 25th flops, and that's the computing power required to train those models. Those ones will be subject to restrictions, and I'm happy to see that. And I think for those of you wondering where that 10 to the 25th power number came from, it's an interesting case of what I would call either one-upsmanship or maybe 10-downsmanship. The U.S., the White House created the executive order on AI, and they came to the conclusion that 10 to the 26th power would be their threshold. So this is literally 1/10 of the computing power is what triggers a set of requirements in the EU compared to the US. And the other great thing I think that's really important about the AI Act, and that's superior to the executive order approach, is that it's not just the 10 to the 26th threshold. There's also a component that can be other qualitative reasons that might cause the EU AI office to think that a model poses systemic risks, and they leave that a little bit open. I think that's super important because you can imagine ways that people would game a number like that, a numerical cap. And just for an example, probably these numbers aren't really disclosed or available publicly, but there's a guess that GPT-4 and Google's Gemini Ultra are the only current models that are above that 10 to the 25th or even 10 to the 26th threshold right now that we know about. The other thing that's important in the AI Act that I was really happy to see is direct mention of deep fakes and watermarking. Those are really big. And then maybe last but not least, staffing up a new AI office. In the US, we're really relying on this AI Safety Institute, which is struggling to get $10 million allocated to it within NIST. And the AI office in the EU and also corresponding offices across the European Union are likely to get much more significant budget allocations, which is necessary to keep up with the technology.
David, I can tell you read that document. That 10 to the 25 number, I would have never heard from anyone about that. So thank you for that. Now, I want to keep it positive. I don't want to be negative, but I know there are some not so great parts of the EU. So I want to ask you, what are your least favorite parts of the EU AI Act and why? And again, I'm going to pick on Theo first.
Sounds good. And I think I see Renata's question in the chat, which is what type of responsible AI practices are encoded in the EU AI Act, specifically around bias and discrimination? I think this question gets to some of the challenges as well. So there's been a lot of pushback and advocacy around specifically issues of emotion recognition and mass surveillance. So I'm going to drop a few links in the chat. Emotion recognition, for those who aren't as familiar with the concept, is the idea that technologies can infer someone's emotional state from data collected around the person. It's a little bit of a controversial concept because it is still unclear whether or not data can really tell your emotional state. And a lot of civil society organizations called for a full ban throughout the negotiations. And in 2023, the European Union adopted a ban on emotion recognition in 4 contexts. So education and workplace, which made it into the subsequent language, law enforcement and migration. But because of pressure from member states, the prohibition on using emotion recognition in law enforcement and migration context was ultimately removed from the subsequent text and received a lot of scrutiny because this affects people who are already feeling special adversity and difficulty. And the deal also allowed exceptions to the ban on emotion recognition in the context of medical or safety purposes, which for many feel is a loophole that could be quite dangerous. Companies already use aggressive detection systems that label images of some people as more aggressive than other people. For example, Black individuals are often labeled as more aggressive than white individuals. And if such a system were deployed in schools or in the workplaces, it could lead to, the fear is it could lead to greater surveillance of Black students or Black workers. And so there are concerns around mass surveillance and also remote biometric identification, RBI. So a critical civil society demand throughout the process was that there would be a complete ban. And it doesn't look like that's happening, unfortunately, for civil society. And so a lot of these issues connect very closely to concerns around bias and discrimination. So there has been pushback by civil society based on the evolution of the text and the ways in which some bans have not been as extensive as they would like.
I mean, that emotional recognition, it just sounds so like sci-fi to me. Yeah, but thank you for your answer, Theo. Arushi, what are your least favorite parts?
Yeah, and what I'll do is I'll actually address Eric Davis's question, which is a lead into what I'm going to get into. So the way the EU AI Act is being discussed is it will apply to any organization or business, regardless of size. If you are offering a AI system or an AI system that is a component of a larger kind of technology product to citizens of the EU. So even if you are a small startup, it will apply to you. However, in the Act, there are certain exceptions that will be made for what they're calling SMEs, small and medium-sized enterprises. That said, though, yes, it's for anyone that offers AI in the EU, any AI product. What's interesting is there are also exceptions. So, and that's what I'm going to go into as something that I'm not feeling great about. If you are developing AI systems exclusively for military and defense uses, you are fully, the Act does not apply to you at all. Similarly, if you are doing R&D work and let's say you're an independent researcher or a small organization that is not putting an AI system on the market, but just doing your own R&D work, have access to a sandbox, most likely the EU AI Act will also not apply to you. But for military and defense use, now, Theo covered a bit of this, right? There's migration issues, refugee rights, emotional facial recognition. There's that world of use cases that a lot of these countries continue to deploy and will be able to under the EU AI Act, especially if they get sign-off from their judicial authorities. They will have to go through some sort of qualification process where they have to submit their use cases to their local judicial authority. But there are countries that are democratically backsliding, like Hungary, Turkey, and having this kind of act fully exempt them from some of their use cases can be problematic. And definitely curious to see where that goes. There's another part which also instills a bit of fear within me as a practitioner, but also as a practitioner, I think there's good that comes out of this. Something that David and I should probably chat about as well, which is the exemptions for these open source GPAI models. They are fully exempt from the requirements that are for all other high-risk models, unless that open source model is also considered systemic risk. Now, the EU-AI Act is very vague about when an open source model will be considered to have systemic risk or not. But I think about a lot of open source models in the market, once they have enough use or downloads, depending on what people do with it, safety layers can be undone, depending on how you fine tune it. Like there's a lot of bad experimentation that can cause harm and can affect people's fundamental rights. And if that's fully exempt or not caught in time, that can be a risk. And so the kind of vagueness around how open source models that have systemic risk will be qualified is something of concern to me. But yeah, David.
Yeah.
Yeah. Yeah, I think there's some really interesting provisions, and I'm wondering how those are going to connect with the exemptions for systemic risk. For example, I have a question about the provisions on watermarking and disclosure. It's not totally clear to me if those would apply to open source models, like, for example, Stable Diffusion, which is an open source image generator. Now we and this gets to one of my least favorite things. My understanding from asking this question of a European Commission official at a press conference is that if I release an AI model, and again, an early version of Stable Diffusion was trained on child sexual abuse material. This was some research that came out of Stanford. So that model is being used, has been used to produce child sexual abuse material. When that material is created, it can be really damaging to the people who may appear in that if it's created to look like a real person. And there are cases where there's a high school in New Jersey where 30 different girls at that high school were victims of non-consensual deepfake pornography or sexual imagery, intimate imagery, or some of the terms used for this. And when that's created by an AI system, especially when the creators of that AI system were so careless as to actually train the system on child sexual abuse material or train it on pornography, I think there's a lot of evidence that some of the systems, including open source systems, probably not limited to them, had different amounts of pornography in their training sets. And then that is used to create now what are sometimes called undressing apps. These are apps that can be used to simply take the clothes off of a person in a photo. Again, it's worth noting these apps in many cases don't work on men. They only work on women. So those kinds of apps, my understanding of it and the models that power those apps, my understanding is under the EU AI Act is that the onus is actually legally on the user. In the legal language of this, the deployer, the person who uses that tool to make that image, and that the model creator does not bear accountability for the outputs of those models. Now, maybe I'm wrong about that, and maybe there's some interpretation to happen, or maybe there's a moment in which one of the AI offices declares models of that type that can produce that kind of content to be liable for it. There's also product liability law and a new AI liability directive that's not complete coming from the EU, and maybe those liability laws will deal with that separately. But that's something that I'm not happy about. I think that model makers should have accountability and liability for facilitating that type of content creation.
Awesome. And to end on a good note, nothing is perfect. It'll get better. I swear. But I want to go back to Arushi, and I know that time is running too fast for my liking, but I want to go back to her because she's the industry person here, and I want to ask you, what are the biggest impact, in your opinion? Right, this is all of our opinion to the best of our knowledge. what's the biggest impact that the EU AI Act will have on industry? And can you talk about the differences between large and small companies and how they're able to be in compliance?
Yeah, I have so many thoughts here that it's hard to kind of qualify what the biggest impact is going to be, but I'll probably like talk about it in three buckets. So everyone's talking about whether innovation will be stifled or not. I think it can slow down, but like in a thoughtful way. It companies will be forced to think about their risk case, um, their risk framework early on. What kind of use case do they really want to sign up for and be held responsible for the entirety of that life cycle now? And what do they have the funds and the staffing to actually support? Because it's no longer just let's develop this model and put it on the market. There's post-market deployment, like post-market monitoring you're going to have to update. There's post-market surveillance you're going to have to manage. And this is if you're a high-risk AI provider. And so given that, everyone's going to have to think pretty early on what they're signing up for when they want to train a model or launch a new AI product. I also think a big shift, which is already happening, is that people are going to start releasing smaller models with very narrow use cases. We're seeing this with Mistral, for example, which is a France-based company that launched Mistral 7B, which is considered a smaller model. Microsoft released Phi 2, which is also considered a smaller model. These are models that probably don't fall into the threshold of GPAI, at least given the definition that David mentioned, which is 10 to the 25th floating point operations. These models don't fall into that, most likely. And so I think a lot of companies will now create smaller models, which is good for them in a few different ways, right? They have narrower use cases that they can plan for, that their deployers and users can plan for. They're using less compute and energy resources to make these smaller models, most likely. And so in that way, I can see that's going to be like a cost mitigation tactic. Lastly, one thing I'm really, really excited to see in the industry is the development of now actual formalized AI auditing. Insofar, we have a few major players like Babel AI. I'm sure there's people in this community that have done consulting in AI auditing. I think Raman Chaudhary, there's a few folks that have done AI auditing and that have some consultancy experience there, but it's not a very formalized space with industry agreed upon standards yet. It's now in the process of getting professionalized with the IAAA, which was launched a few months ago. But I think it's going to become a new space. And to see the professionalization of AI auditing, to see it become more formally a place, like there's academic papers coming out about, okay, should we borrow from financial services and try to pursue criteria-based auditing, which is how SOC 2 is done. There's just a lot more thought going into how the AI auditing industry will look like. And I think the EU AI Act, the executive order, these regulations have a big role to play in the development of that new sub-industry. So I think that will be pretty exciting. And then lastly, you asked about small and medium-sized enterprises. Once again, they're going to have to think about if they have the process and the staff in place to do what is entailed and required of high-risk model providers. I don't see small and medium-sized enterprises developing high-risk models or large language models anytime soon. Like my own company now is going for very narrow use cases because that's what we can afford to do. And so that's kind of what I'll throw out for now.
No, that's really helpful. And I wish I could follow up, but in the interest of time, I wanna pick on David now because I also want to know the biggest impact on government. And I know that the government is doing a lot. They're hiring like crazy, and they're taking this really seriously. So I wonder, David, if you can talk to us about the biggest impact on government.
Yeah, well, actually, this is an area where there's a lot of similarity with the US. The United States federal government right now is doing a big AI hiring surge. Many federal agencies will now have chief AI officers. And in Europe, we're going to see similar, but probably more investment in hiring of AI talent to staff the new AI offices. and then to do all of this enforcement. And I think also, again, similar to the US, this is an area where the executive order was probably most impactful, and that's the White House executive order on AI from a couple of months ago, is directing the federal government of the United States about how it can and cannot, or should and should not, use AI in different situations. And that's definitely going to be happening in the EU also. And a lot of people in European governments will need to become very careful about the ways that their government agencies think about using AI, whether it's AI systems that they produce or what vendors they engage with. And we talked about the prohibited uses earlier. I think both Theo and Arushi touched on that. The one that's pretty important is this question about social scoring systems. Now, this is something that people largely associate with China, but I thought it was interesting and worth mentioning that is officially ruled out for the European Union. The European Union will not be using social scoring. And there are many situations in which in the US that we don't have a social scoring system, but we do have this credit scoring system. And the EU Act talks about social credit. It'll be interesting to see as these systems evolve and as different vendors have different offerings in the EU, which ones are ruled out completely, or how they deal with getting around or complying with this in the case of credit or companies that do business in both the EU and the US. Yeah, I think I'll leave it there.
That's interesting. I never thought of my credit score as being a social score, but it's actually not out there. It makes sense. It makes sense. Thank you.
Yeah, I mean, it's a component of the Chinese scoring system. It's not the only thing. Yeah.
No, that's very interesting. Okay, Theo. I want you to think and brainstorm with me. What are some of the opportunities that the EU AI Act presents for civil society organizations?
Sure. And I'll also add to David's previous comment. For those of you who are Black Mirror fans, there was a whole episode on social scoring, which was fascinating and was compared to the Chinese model because it was being evolved right around the time that the episode was released a few years ago. And I remember thinking that it was totally far-fetched, couldn't happen. And then, in fact, it actually was in some ways manifesting just before our eyes. So yeah, and
oh yeah, we watched that episode in my scenario planning class. Actually, I love that one. I just dropped a link in.
I see others in the chat are big fans as well. Yeah, Black Mirror is predicting the future, one episode at a time. So in terms of opportunities for civil society, I think that civil society plays a really important role in these conversations as a convener and also a researcher of the impacts of policy on communities, specifically disenfranchised communities. So I think that civil society has the opportunity now to bring together different stakeholders in conversation to ensure that as the act moves forward towards implementation, that it doesn't have unforeseen consequences. And if it does, how do we measure those consequences? How do we understand them? And how do we modify legislation or regulation accordingly? In the fall, I did a lot of work with Partnership on AI, which put together an AI policy forum in London and also a policy steering committee that brought together folks from all of the different stakeholder sets so that we could think through some of these questions and provide information that was informed to government as it was moving forward in these conversations. I also think civil society plays an important educational function. So it educates the public on policies like the EU AI Act. And I think that last, there are opportunities for additional advocacy because it's still an evolving process. It's not totally complete yet. And so there are opportunities for civil society to advocate more effectively on issues that they feel are really important, and perhaps not entirely touched upon.
Awesome. So I'm going to move on to the next question because we're running out of time. I thought we had all the time in the world. But I do want to make a comparison between the U.S. executive order and the EU AI Act. We know that the U.S. and the EU are honestly the two powerhouses, if we don't count China, in AI. And so they're doing a lot of coordination. But how do you see these two orders, these acts relating to each other? And I'm going to go back to you, Theo.
Sure. Yeah, absolutely. So I would say they have different areas of focus. So the U.S. executive order is primarily focused on government application of AI systems. So like David was saying earlier, it involves hiring a lot of folks who are overseeing how AI is being implemented in government agencies. The EU AI Act is industry focused. It has a much larger reach beyond government. So it has a very large breadth and applies to AI systems that are being developed and also applied in industry within the European Union. And I think that its risk-based approach is also a slightly different approach. I think it's worth noting that interoperability is really important moving forward. So we're seeing a plethora of regulatory frameworks and legislative frameworks that are being advanced in Europe, in the US, and also globally. And so it's helpful if they are interoperable with each other. So, for example, there are the OECD AI principles, the UNESCO recommendation on the ethics of AI, the G7 AI Hiroshima process, and others are all looking to set guardrails for advanced AI systems at the global level. And these create different regulatory burdens on companies that are operating globally. And so to the extent that these different systems can coincide, it is helpful to organizations, to industry partners that are looking to comply with regulation. So there are differences and they're notable, but I think it's also important to talk about how the systems can be talking to each other.
Okay, I'm going to give you a break, Theo, because I've abused you. So I'm going to move on to David. David, how do you see this two relating?
Yeah, so I think there are just two words you need to know when you're thinking about comparing the EU AI Act to the White House executive order on AI. And the EU AI Act is more forceful and more durable. Forceful in the sense of it applies to the private sector in many, many different ways, and it has the force of law, whereas the executive order mainly applies to things that governments will and won't do, can and can't do. And then durable, Trump, if you weren't following, Donald Trump, if elected president again, has announced he will be a dictator only on the first day of his presidency, and will eliminate the executive order on AI that Biden did. So we can just say goodbye to the executive order if Trump is elected. I mean, maybe he won't do that. It's not totally clear to me still that all these AI laws really fall on those partisan lines. The Trump administration did put some regulations in place on AI, but that's the big thing. But also on this point, I think a lot of people in the US have forgotten about the White House voluntary AI commitments. And those came out in July of last year. And then September, some more companies signed on. So as far as I know, there are 15 companies, but it's really almost all of the big AI companies in the US that have signed on to those voluntary commitments. And those commit the companies to doing things. Again, it's voluntary. There's not an enforcement mechanism, but those commit the companies to doing things that are not spec'd out in the EU AI Act. They commit the companies to guarding the weights of their models very closely for unreleased models. They commit the companies to implementing a watermarking system with watermarks that are difficult to remove. So watermarking is like mentioned, but not even spec'd out in the AI Act. So I think, again, we gotta, don't forget about the voluntary AI commitments.
That's a good point. Arushi, do you want to jump in really quick, or do you want me to move on to the next question?
I do have one quick thought to add, which is I think the EO, the executive order, is very self-aware about competition and international competition. One thing I'll call it is the executive order asks infrastructure providers like AWS and Google Cloud to have systems of know your customer, where if you are selling GPUs for the purposes of training a large language model and they are being purchased by a foreign entity, like let's say in China, then the EO wants these companies to be tracking that. And so I think the US is consistently talking about things in a competitive way, whereas the EU AI Act does try to be pro-innovation, but I don't see that competitive fear come through in the way it's designed or the way it's talked about. And of course, it doesn't mean to say it doesn't exist, but I think the US is much more nervous about competition, global competition, when it comes to AI.
Awesome.
I'll just say on that one, like NVIDIA has this history of, whenever those export controls are implemented and spec'd out, they release a new system that falls just below the threshold for the controls that they can still sell to the prohibited customers. So, and I think we'll see something like that, like a gaming of the 10 to the 25th provision too.
Yes.
I think we'll see people make a bunch of models that are all 10 to the 24th and then wire them together and get around that. Or they'll release a model that's 10 to the 24th, and then if you do a little tweak to it at home and spend some time on your own GPU or whatever on your system, then you could turn it into something really powerful. So we have to look out for those things.
Yeah, agree. And just, to the audience, just know that I am looking at your questions, and I think we are, as we are going, we're answering them. So I have an eye on your questions, and I know Eric asked about the timeline, and we're going to talk about that. That's actually like one of our next questions coming up soon. So I want to ask Arushi, Theo, or David if you want to jump in as well. But Arushi, I'm going to go to you first. Do you think the EU AI Act will stifle innovation? Because that's what I hear from a lot of mostly industry people, and I want to know if you think that's true or not, or if it's just the same old false alarm.
Yeah, at the risk of not being too repetitive with kind of my previous comments, one thing that I didn't mention before was training data. So when OpenAI and other large players released their LLMs, I think I can comfortably say there was a lot of blatant disregard when it came to what data these large language models have been trained on historically. That's why there's so many lawsuits. That can't happen anymore. But that also means that like the access to diverse large sets of data is going to become more limited. And so I believe what's going to happen is a lot of people that want to develop large language models will now have to go through actual permission queues, media partnerships. OpenAI has already announced some. Companies like mine have now looked into like actual partnerships with publishers so that we can use their data in a licensed way, even if it's copyright, but like getting their approval and getting licensing to do so. These are the new steps that are being introduced. And so, like I said, I think it will slow innovation if you're going for high risk AI innovation, or if you are developing GPAI. I don't think it'll fully stifle it. I think it'll just become more thoughtful. And lastly, I do want to talk about compliance costs. There's a really good study that I read, and I will share it here, by the Future Society, which talks about how compliance costs are actually shouldn't be that high. What's always going to be higher is probably your compute, staffing, training. So let's hope that compliance costs don't get prohibitively high, but you are just being thoughtful as you remain compliant.
Right.
So that's.
Yeah. Theo, I think you've had quite a bit of a break. What do you think?
Yeah, I agree with Arushi. I think I'll add that the Act tries to incentivize and foster innovation by promoting regulatory sandboxes. So it creates spaces for organizations to experiment with AI. But there is always the concern of regulatory capture, or this idea perhaps that if the requirements are the same, regardless of the company's size, that smaller companies bear, and that it has a regressive effect on smaller companies because they don't have the same resources that larger companies have to deploy towards regulatory compliance. And so there has been a conversation in the aftermath of GDPR, which was rolled out at this point about 10 years ago, focused on data privacy, around whether it has actually stifled innovation and specifically had a disproportionate adverse impact on smaller and medium-sized businesses that couldn't comply as readily as bigger businesses. There is competing evidence. I've read evidence that shows that it actually has had a regressive impact, or an impact that was disproportionate bigger on smaller companies, but there's also evidence to the contrary. So the jury's out a bit, but certainly it's an ongoing conversation. I think the EU AI Act and also the UK-based legislation that's ongoing around online safety, which also tiers on the basis of the size of an organization, is trying to learn from past mistakes or past situations to ensure that smaller players have a real competitive play, that they can engage just as readily and comply with perhaps fewer obligations. So there is an ongoing conversation about innovation and whether this will allow smaller and medium-sized businesses to continue to operate.
And that's interesting because when GDPR was coming up, I know it came into effect in 2018. I heard the same arguments that it's going to stifle innovation and that the EU will be left behind. And in the end, the GDPR is actually, stronger in like the model for other countries to build their own privacy legislation. So maybe it won't be as bad as people think. David, do you have anything that you want to add?
I was going to jump in on this one. I think one thing to remember is people talk a lot about regulation stifling innovation, but there's also regulation that creates markets. And actually, GDPR is super interesting as an example. Now, I'm really not a privacy expert, but I heard a talk recently that talked about the market that GDPR created for compliance. And ironically, one of the big examples is this company OneTrust, which is headquartered in Georgia, but that has made a lot of money on helping companies comply with GDPR. And I think, we talked about auditing. Now there's going to be a huge market for AI auditing professionals that's going to grow out of this. And I think we'll see quite a few other market for watermarking tools, authentication tools, detection tools. So I think there's a lot to really look forward to, a lot of business opportunities to look forward to that will help companies comply with this in ways that serve people better.
Agreed. Okay, so I know we only have 10 minutes left. And I want to ask 2 more questions and maybe then let the audience ask questions. But it's you would think there's nothing missing in this 20,000 word document, right? But I feel like there may be a few things that this act didn't address. And I want to start with Theo. What do you think that this act is missing, or something that wasn't addressed?
Yeah, and I realized I was not muted, and I was responding to the question in the chat. I think it's an interesting question. Yeah, absolutely. So I would say, again, as I mentioned earlier, perhaps stronger language around issues like prohibiting emotion recognition in the context of law enforcement and migration, removing the exceptions to the ban on emotion recognition for medical and safety purposes, and then also considering a full ban on remote biometric identification. So stronger language on those issues is something that I'm seeing a lot of conversation around.
Okay. And then Arushi?
Yeah, one thing that is kind of unclear to me that I feel like the EUA Act could benefit from more detail is where onus lies on the provider and developer of an AI model versus what they call deployer or user of an AI model. So there is an entire section where deployers of high-risk AI models have to inform the provider if some fundamental rights are affected or if things go bad, to summarize. But it's pretty vague. And as someone that is probably going to be in the position of a deployer and will also be in the position of a provider, we're working with our legal team to really figure out, okay, so what do we have to inform and who and when? I'm thinking about ChatGPT and how some of you might be familiar. There some researcher used ChatGPT to turn it into Chaos GPT. So it was fine-tuned to become a really chaotic, unsafe version of GPT. And so that's an example of, okay, let's say the original provider, aka OpenAI, has ticked off all the boxes. So now if Chaos GPT has been created, who will be liable for what? That's still not clear to me. And the way they've attempted to address this is by generally mentioning something called post-market monitoring, which means that OpenAI needs to be monitoring the use of GPT once it's deployed, so on and so forth. But in practice, I don't know how a company can preempt and monitor every download or every use of their model. And so that's an area that I'm like, let's see what happens. The other area is public funding and investments. So I'm surprised the EU has not come out with some sort of large announcement on, hey, we're launching this regulation, but we're also going to be investing this much money in the industry to like counterbalance the regulatory concern that comes with these bills being passed. For example, the US did announce some major funding when they talked about the executive order. For example, the NSF, I believe, announced an investment of 10 million in Safe AI, although David's saying that itself is controversial. But I hope that when the act finally passes, which is apparently April, that there is going to be some larger announcement that's like pro-innovation to counterbalance some of the regulatory, the fist that comes down in a few months. So yeah, those are my thoughts on what's missing and what could be added.
David?
Yeah, I think, maybe this is a don't look a gift horse in the mouth situation, because I actually wasn't even expecting watermarking to end up in the EU AI Act, and it did. And then I went to look for it and read all the provisions about it, and it doesn't say that much. And so I think that there are going to be standards that are created by this European standards organizations called CEN and CENELEC. But that could take a while. I don't know exactly how long. And so, selfishly for me, I'm helping a California legislator write a bill about AI watermarking right now. And I sure wish the EU had gone a little further and put some more detail into that. But maybe this is a case where there's going to be some back and forth, and California is actually going to lead on some of this stuff, if anything passes here.
Yeah. Okay. Well, we only have 5 minutes left. And so I'm going to do the last question. And I know other people have the same question. When will this thing go into effect? I feel like I've been hearing about this for the last 2 years, and they're still working on it. So what's taking so long? When will it actually come into effect? And when will companies have to start complying with this? So I'm gonna, Arushi, you probably know more than anyone else because you're in the industry.
Yeah, so what we're hearing is that in April there will be the last vote, because now the law is in the hands of a committee, the Civil Rights Committee. I'm messing up the name, but there is one final vote. And then what we're hearing is that after that vote in April, assuming everything goes well, about 2 months after that vote, the law will come into effect. So it'll become a law of the land, but companies will have 2 years to be for things to be fully in effect. So they'll have 2 years to plan in general after the 20th day of the passing of the bill. Now, there are a bunch of exceptions. So even though companies will have 2 years, many will not have 2 years. Many will have much less than 2 years. So if your AI system falls into the list of banned AI uses, that ban will apply 6 months after the law is in effect. There's codes of practice that will be required for most AI providers, especially those that have lower risk systems. They just ask for codes of conduct, acceptable use policies. Those will have to be ready within 9 months of the EU AI Act entering into force. There's a whole list, so I would recommend that people talk to their legal counsel, but these are the things that we've been thinking about, which is 2 years, unless you fall into an exception where it could be 6 months or 9 months.
Gotcha. David or Theo, you want to add anything? No?
Arushi hit it.
Okay. Yeah. And, you would think that's a straightforward question, right? Not with the EU. Well, I think we have time for maybe one question, or I'm not sure. Do we? Is there anyone who wants to ask a question? So you can just come off mute and ask. We only have 2 minutes left. Anyone? No? It sounds like we answer all of the questions, so which is okay. Well, in that case, I want to be respectful of everyone's time. I want to thank the panelists for taking an hour out of their day to answer all of these questions. I hope this was very useful for everyone. And I think we have to do one for the UK because none of this includes the UK, right? So I think we eventually we're